Good evening po sa lahat. Si Fiscal AJ po ito. Tonight, we are going to answer the question of whether or not reckless driving is a crime. The only simple issue here is, as I said, whether or not reckless driving by itself is a crime. But first, ano ba ang isang crime? Crime is either an act or an omission in violation of a penal law. Now, an act is a bodily movement that produces an effect in the external world. For example, X stabbed Y, resulting in the latter's death. This act, meaning this act of X in stabbing Y, is in violation of a penal law, the revised penal code, which punishes a person who kills another. On the other hand, an omission is a failure to act or a failure to perform a duty which, if not performed, is punishable by law. For example, a jail warden who delays the release of a prisoner after being ordered by the court commits the crime of delaying release under Article 126 of the Revised Penal Code. The omission here is the jail warden's failure to perform a duty prescribed by law. But an act or omission cannot be considered a crime if there is no law punishing it. In other words, there is no crime when there is no law punishing the act or omission. The law that punishes an act or omission is called a penal law. What then is a penal law? A penal law defines criminal offenses and provides a specific punishment for them. It has three essential elements. The first element is it defines crimes. Second, it treats of their nature. And third, it provides for their punishment. Now, the punishment can be in the form of either a fine, meaning pagbayad ng multa, or imprisonment, pagkabilanggo, or both such imprisonment and fine. The question now comes to mind. Is reckless driving a crime? Reckless driving is defined under Section 48, Article 5 of Republic Act 4136, otherwise known as the Land Transportation and Traffic Code, as follows. Ito po yung provision ng reckless driving. No person shall operate a motor vehicle on any highway recklessly or without reasonable caution, considering the width, traffic, grades, crossing, curvatures, visibility, and other conditions of the highway and the conditions of the atmosphere and weather, or so as to endanger the property or the safety or rights of any person, or so as to cause excessive or unreasonable damage to the highway. Now, reckless driving is a crime because it is an act that produces an effect in the external world in violation of a penal law. Let me give you an example. X, who was in a hurry to go home, was driving his car more than the speed limit. Aside from driving more than the speed limit, the visibility of the highway was not clear, so much so that he almost hit Y, who was crossing the highway. X then lost control of the vehicle and tried to hit on the brakes. However, the vehicle instead swerved and fell onto a canal. When the police arrived at the place of incident to investigate, they found skid marks on the highway indicating that X drove more than the allowable speed, and thereafter they interviewed Y, who told them that he was almost hit by the car of X. Here you can see that even if there was no injury or death to persons or damage to property, the crime of reckless driving is still produced because the, the driving of X endangered the safety of Y when Y attempted to cross the highway. Here, X is criminally liable for reckless driving under Section 48 because, as I said, he drove his car on a highway recklessly that endangered the safety of Y. Question: is it required under Section 48 that there should be an injury to persons or property as a result of reckless driving? The answer is no. Section 48 merely requires that the driver operates the motor vehicle recklessly or without reasonable caution that endangers the property or the safety or rights of any person. Nothing in the said provision states that there should be injury or damage to any person or of the property of the said person. Merely endangering the safety or property of any person is enough to constitute the violation. What is therefore the penalty for reckless driving? Section 56, letters L and M, Article 1, Chapter 5 of RA 4136 provides that a penalty of fine of not less than 10 nor more than 50 pesos shall be imposed on the offender, and that in the event that the offender cannot pay the said fine, he shall be made to undergo subsidiary imprisonment as provided for in the revised penal code. What is the nature of this penalty of fine in Section 56, letters L and M? It is clearly in the nature of a criminal penalty because of the provision on subsidiary imprisonment in case of failure to pay the fine. Section 48, in relation to Section 56, letters L and M, is therefore a penal provision because it defines a crime, treats of its nature, and provides for its punishment. Now, who imposes the penalty of subsidiary imprisonment in case of failure to pay the fine? Is it the Land Transportation Office? The answer is no. Only the court can impose the penalty of subsidiary imprisonment in case the convicted offender is unable to pay the fine. Now, since it is only the court that can impose the penalty of fine and subsidiary imprisonment in case of failure to pay the same, it follows that a case must first be filed in court to prove the guilt of the offender in reckless driving. Question: how does the court categorize reckless driving? Is it a civil case, an administrative case, or a criminal case? Under the rules on expedited procedures in the first level courts, approved by the Supreme Court en banc on March 1, 2022, and which took effect on April 11, 2022, the Supreme Court clearly categorizes violations of traffic laws, rules, and regulations under the category of criminal cases to be governed by the rules on summary procedure. Another question: is reckless driving a violation of traffic laws, rules, and regulations? The answer is yes. Section 48 on reckless driving is categorized under miscellaneous traffic rules in Article 5 of RA 4136. Other miscellaneous traffic rules include right of way for police and other emergency vehicles under Section 49, tampering with vehicles under Section 50, hitching to a vehicle under Section 51, driving or parking on a sidewalk under Section 52, driving while under the influence of liquor or narcotic drug under Section 53, obstruction of traffic under Section 54, and duty of driver in case of accident under Section 55. Reckless driving, therefore, is a crime under Section 48 of RA 4136, and that any case filed in court pursuant thereto is categorized as a criminal case under the rules approved by the Supreme Court en banc. Question: if injury or death or damage to property is caused to another person or of his property because of the recklessness of the driver, will the crime still be reckless driving? The answer is no more. The offender this time will be liable for the felony of reckless imprudence resulting in physical injury or reckless imprudence resulting in homicide or damage to property as the case may be, as defined and penalized under Article 365 of the Revised Penal Code as amended. Do not be confused between reckless driving as a crime under Section 48 of RA 4136 and reckless imprudence as a felony under Article 365 of the Revised Penal Code. Reckless driving by itself is a punishable act even if it does not cause injury or death to persons or damage to property. Reckless imprudence, on the other hand, is a culpable felony. Now, imprudence as defined is a deficiency of action in avoiding an injury due to lack of skill. It implies a failure in precaution or a failure to take the necessary precaution once the danger or peril becomes foreseen. It becomes a felony only when it results in injury or death to persons or damage to property. Example of reckless imprudence. X was following Y's vehicle on the highway. As X was in a hurry to get to his destination, he attempted to overtake Y's vehicle by traversing on the opposite lane, which happens to be traversed by Z, who was then driving his motorcycle in the opposite direction. As a result, X hit Z's motorcycle, resulting in the death of Z. Here, X clearly failed to take the necessary precaution in seeing to it that the opposite lane was free of oncoming motor vehicles before attempting to overtake Y's vehicle. Now, let's go to another topic. I am talking about the case of People versus Marlon Cristobal, GR number 234207, dated June 10, 2019. The question is, does this case of People versus Marlon Cristobal prove that reckless driving is not a crime? Let us first go through the facts of the case. Cristobal was charged for illegal possession of dangerous drugs in the regional trial court. According to the police, Cristobal was flagged down at a checkpoint for not wearing a helmet. He also failed to show the certificate of registration and the OR of the motorcycle he was riding or driving. While the police officer was preparing the traffic citation ticket, Cristobal allegedly ran away, but the other police officers were able to apprehend him. He was brought back to the checkpoint where he was searched for deadly weapons, but nothing was found. However, the police noticed that Cristobal's pocket was bulging and ordered him to remove the object from his pocket, which was a small plastic bag. When the police opened the same, they found 7 plastic sachets containing white crystalline substance, which turned out to be methamphetamine hydrochloride, or more popularly known as shabu. The RTC convicted him of the charge. According to the RTC, the search made on Cristobal was justified under the stop and frisk rule. On appeal in the Court of Appeals, the Court of Appeals affirmed the conviction of Cristobal. On appeal in the Supreme Court, however, acquitted Cristobal. The reasons cited by the Supreme Court in acquitting Cristobal are as follows. First, there was no valid search incidental to a lawful arrest. There was no arrest to speak of because the violations committed by Cristobal are both punishable only by a fine. Take note that the fine under RA 10054, otherwise known as the Motorcycle Helmet Act of 2009, is in the nature of a criminal penalty, while the fine under LTO Department Order number 2008-39 is in the nature of an administrative penalty. There being no lawful arrest, the sachets of shabu were discovered through an unlawful search and thereby inadmissible in evidence against Cristobal. Now, the Supreme Court further said that the case of Cristobal is strikingly similar to the case of Luz versus People. In the said case, the Supreme Court likewise acquitted the petitioner because the failure to wear a helmet under a city ordinance or penalized under a city ordinance is punishable only by a fine. Now, under the rules of court, a warrant of arrest need not be issued if the information or charge was filed for an offense penalized by a fine only. It may be stated as a corollary that neither can a warrantless arrest be made for such an offense. Now, the SC also stated that neither could the search on Cristobal be justified as a valid stop and frisk search. However, we will no longer discuss it here because it has no bearing to the question of whether or not reckless driving is a crime. Now, does the Cristobal case prove that reckless driving is not a crime? The answer is no. Why? First, the case is about the illegal search made on Cristobal that led to his acquittal of the drug charges. It does not talk about reckless driving and whether or not reckless driving is a crime. Second, there was no lawful arrest to speak of, not because Section 7 of RA 10054 is not a crime, but because the violation imposes only a criminal penalty of fine. To reiterate what the Supreme Court said in Cristobal, a warrant of arrest need not be issued in the case of a person who violates a penal law that imposes only a penalty of fine. Neither can a warrantless arrest be made for such an offense. Third, it is wrong to say that it is not a crime when the law imposes only a penalty of fine. In criminal law, it is basic knowledge that punishment for a crime can be either a fine or imprisonment or both such imprisonment and fine. And fourth, nothing in the Cristobal case says that a traffic violation is not a crime. To reiterate, violations of traffic laws, rules, and regulations are categorized as criminal cases governed by the rules on expedited procedures in the first level courts. This was approved by the Supreme Court en banc on March 1, 2022, and which took effect only recently on April 11, 2022. The assertion, therefore, that the Cristobal case proves that reckless driving is not a crime or that a traffic violation is not a crime is highly erroneous. Kung talagang krimen ang reckless driving fiscal, bakit walang nakakasuhan sa korte? Dalawang klase po kasi ang fine sa reckless driving, administrative at criminal. Hindi na ini-enforce ng LTO ang criminal aspect ng violation dahil masyado na pong maliit ang fine na nakalagay sa Section 56 letter L of RA 4136 from 10 to 50 pesos lang po. Magfa-file ka pa ba ng criminal case kung alam mong ganito kaliit ang penalty? Very impractical na po. This explains why walang nakakasuhan ng reckless driving sa korte. Pero hindi ibig sabihin na hindi na nag-i-exist ang reckless driving as a crime. Hanggang hindi pa ito nare-repeal, it continues to be a crime under Section 48 in relation to Section 56 letters L and M of RA 4136. Samantalang ang administrative fine for reckless driving under DOTC Administrative Order number 2014-01 ay 2,000 pesos for the first offense, 3,000 for the second offense, and 10,000 for the subsequent offense. So you can see now the difference between the fines, no? As imposed under Section 56 and the fine imposed under the said DOTC order. In addition to the said administrative fine na ini-impose ng DOTC through the LTO, the driver's license shall likewise be suspended for a period of 3 months pag second offense na and 6 months suspension for the third offense. But after the third offense, revocation na po ng driver's license. Now, how is this administrative fine enforced? Suppose X is flagged down for reckless driving. The LTO enforcer will issue a temporary operator's permit or TOP to X, after which his driver's license will be confiscated. Take note that the TOP is actually a ticket issued to a driver apprehended by the LTO for violating traffic rules. It serves as the driver's temporary license for 3 days before the driver claims his license from the LTO. Now, if X admits his violation, meaning hindi na po niya iko-contest, no, yung reckless driving, there is a procedure and submission of some requirements that he must comply in order to settle and pay the violation. But if X contests the violation, he can file a written protest within 5 days from the date of apprehension. The failure to file a written protest shall be considered as an admitted violation, and admitted violations shall be immediately executory po. So, makikita nyo dito na merong due process na sinusunod ang LTO before they will impose or collect the administrative fine. Ano ba ang legal basis ng DOTC sa kanilang authority to impose administrative fines? This authority po is based on Executive Order number 125 and Executive Order number 292, otherwise known as the Administrative Code of 1987, which states the power of the DOTC to establish and prescribe the corresponding rules and regulations for the enforcement of laws governing land transportation services, including the penalties for violations thereof. So yan po ang discussion natin about reckless driving. I hope hindi na ho ma-confuse no, ang mga viewers kung ano ba talaga ang nature ng reckless driving. And it is my stand that reckless driving is a crime under Section 48 in relation to Section 56, letters L and M of RA 4136. Salamat po.